Example of a protected conversation. I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. Now, what we're going to do, leading on from last week, is we're going to talk about a situation, a practical example involving a protected conversation. So, a little bit of background to this one. We're talking to an employee named Billy, and he is at risk of redundancy. So, what I'll do is I'll guide you through how to start that kind of conversation, and then we'll have a little discussion about what it all means and when to use it at the end. So, Billy, thank you for attending this conversation. Unfortunately, as you know, we've had several contracts that have been cancelled over the last few months, and this is having quite a serious financial impact on us. As a result of it, we're actually questioning whether we need the same levels of staff that we used to, and as a result of that, we're looking at potentially making redundancies. So, your role is one of the roles that we've identified as potentially being at risk of redundancy. And therefore, I'd like to offer you the opportunity to have a protected conversation under Section 111A of the Employment Rights Act 1996. So, what you do after that is you then continue the conversation into what you are offering the employee, basically to waive their employment rights and to bring their employment to an end. If you have a pre existing dispute with the employee, then it's probably best not to be using this kind of conversation. And it may well be that you end up going through quite a great deal of the redundancy process or whatever other process applies before you start having a settlement discussion of a different nature, a without prejudice conversation, which we will discuss in the weeks to come. So if you have concerns about discrimination, automatically unfair dismissal, breach of contract, unlawful deduction of wages, or a complaint from the employee about things relating to their employment or the way that the business is run or conduct from other members of staff, then it's likely that you probably will not want to be using a protected conversation, bearing in mind that a protected conversation only protects the business against claims of ordinary unfair dismissal. It doesn't protect the business against any other sort of claim. So I hope that's explained things in a bit more detail. As I say, we will move on next week to consider a without prejudice conversation. But in the meantime, if you'd like to open the door on employment law, come to the Hironator.